Good afternoon. I'm Joe Hyde. I'm editor of the Gazette, and I want to welcome you today to the workshop on Freedom of Information 2013. Ralph Rotten of the Independent and Colorado Business Journal was supposed to be here to do the introduction. However, he's stuck in deadline right now, so I'm doing it instead. We're very honored today to have two experts on open records. And first I want to state, and Ralph thinks the same way, that this is being sponsored by the Gazette, the Independent, and the Colorado Springs Business Journal. And the reason why we come together is because we think it's not only a media issue, but it's a public issue as well. And this is a very important issue to this city, especially considering what has happened recently with the new fees being imposed by the city on open records. So we wanted to offer this workshop to not only the media, as you'll see reporters and editors from both publications here, but to the public as well. And so we're honored today to have Stephen Zansberg, Denver attorney and expert on open records. He's got a long name with a firm that he's with, but also Jim Clarke, who's head of the Associated Press based in Denver. They're also part of the Colorado Freedom of Information Council. So to talk to you and then answer your questions about open records, here's Stephen and me.
Good afternoon. Thank you all for coming. I want to thank Joe and the three press entities who are co-sponsoring this, and thank the Gill Foundation for making its facilities available to us. I intend to spend about 25 minutes doing an overview of the open records law, and Jim will then chime in with his perspective as bureau chief for the AP, not just for Colorado, but for the Rocky Mountain region, about some of the issues that his reporters are encountering. And then we'll save about a half an hour for Q&A. So before we get underway, just so I know who we're talking to, by show of hands, how many of you are members of the press or associated with the press? All right, and so is it safe to say that the rest of you are citizens and some familiar faces in the crowd? I do want to, so we're in the introductions portion. I'm going to do an overview of the law, talk about the process for getting access to records, talk about the current issues and the likely outcomes. And unlikely outcomes, I've given you two handouts. One is a two-sided document that on one side is a three-column chart that sort of lays out where the open records law is in the scheme of Colorado. Sunshine statutes, for lack of a better word. There's the Criminal Justice Records Act, Public Records Act, or the CORA, as it's referred to, the Colorado Open Records Act, and then the third column is the Colorado Open Meetings Law, which also dovetails and interacts with the Open Records Act in some respects. I won't be talking about columns 1 and 3, only about the Open Records Act. During Q&A, we can talk about criminal justice records, records in the hands of the police department, sheriff's department, Department of Corrections, district attorney's office, or a court of law handling criminal matters. So today's presentation, at least what I'll be doing, will be focused only on the middle column, the Open Records Act. The other side of this handout, so you know, I may be referring to it later, is about fees. Issue that Joe mentioned, particular interest here. You have that on the backside of your sheet.
It almost felt blank.
Wow, I'm sorry. I'll make that available on our website. It's all right. Then that's good to know. Then the second handout is when I say recurring issues and likely outcomes, it's a free-sheet. Do you have that one that says documents and likely to obtain documents are not likely to retain. And it's actually a document that's a couple of years old, it needs to be updated, but at least it has case law citations for and statutory citations for documents that are open or closed that we'll be talking about in the course of the test. And then, of course, costs on the blank part of your sheet. And then the real world is really going to turn it over to Jim. So a brief overview of the open records law. And before I get into that, last bit of pointing you to other resources. There are two really helpful guides to the open records law. There are more than two, but I recommend to you two. The ACLU has on this website a very thorough guide to open records laws in Colorado. I don't have a copy of that with me. What I did bring is the Colorado Press Association puts out, this is actually a large version of a pamphlet that's about this big and will fit. There it is. See, I got the prop. Jim has the prop. Hold on. That's a brochure that's available to Press Association members. And it fits in your pocket, and it's a very short 16-page guide to the open records laws, and also talks about open meetings as well. The benefit of this is the current version, the one I'm holding, is out of date, but this says it's sponsored by Governor John Hickenlooper, Attorney General Don Suthers, the Colorado Press Association, and the Colorado Freedom of Information Council, upon which both Jim and I serve. And so the fact that it's been endorsed by and bears the name of the governor and the attorney general can be used by you when you're discussing matters with a government. Last show of hands, who here is associated with a government entity of any kind? Thank you very much for coming. I really appreciate your being here. So this brochure is not just an advocacy piece, presenting the point of view of the Press Association and the Colorado Freedom of Information Council. It has been approved and endorsed by the governor of the state and the attorney general of the state. So it's available. I don't have copies for you. I tried to bring copies today, but they're not presently available from the Press Association, but they are available on the Colorado Press Association website. So if you go to their website, there's a search box in the upper right-hand corner, and type in Sunshine, you will find a PDF, like this exact PDF of this pamphlet.
Well, these are handy because you can shake them like this and feel righteous.
Secondly, there's another guide. There's an organization in Virginia called the Reporters Committee for Freedom of the Press. And it has wonderful resources. I commend their website to all of you, regardless of what we do, but particularly members of the press. It's rcfp.org, Reporters Committee for Freedom of the Press. They have wonderful resources on a whole number of issues that are timely. It's just a great, rich website. But one of their guides is called the Open Government Guide. They also have a federal Open Government Guide involving FOIA, which I know Jim's going to talk about a little bit. This guide is called the Open Government Guide, and it's fairly much more detailed analysis of states' open records laws, ours. There's one for each of the 50 states. My law firm has produced one from Colorado for a good number of years now. It's both open records and open meetings. It's searchable, and if you want to compare what other states, or if you're looking at information in neighboring states or anywhere else in the country, you can go and look at what their state's laws are at rcfp.org, Open Government Guide. Now, let's see if I can make this work. So the Open Records Act in Colorado declares as part of the legislative declaration at the outset of the act that it is the public policy of this state that all public records shall be open for inspection by any person at reasonable times, except if provided in this part, or as otherwise specifically provided by law. And so we begin the Open Records Act with this broad declaration that all public records are to be available at any reasonable time, unless there's a specific exception, either within the statute or some other statute that may apply. And this Reporters Committee guide is very good at surveying by category records, whether or not some other statute extraneous to the Open Records Act declares records confidential. There are a whole host of records statutes that specifically declare certain records are confidential. And under the Open Records Act, that would be specifically provided by law. They're not available. But the structure and the way to think about the Open Records Law is we start with what is a public record, and then how can it be accessed? Is it open or is it declared closed, mandatory, or permissively closed, if you will, permissively available for inspection? And then later we'll talk about fees and redaction and all of the permutations. But in way of a quick overview, which records are public records, and then are they open or closed? So I should note that because of that very broad legislative declaration, courts are instructed and have generally applied a broad presumption. It's a statute that is for the benefit of the public. It provides a right of access to the public's records, even though they call it public records. The whole way the statute is defined is they are public records, and the folks in government who maintain those records and make them available to us are the custodians of the public's records. They're the public's records, and they are the custodians of the public's records. Now, not every public record, even if it is a public record, is available for inspection. There are countervailing policies that weigh against every record in the possession of a governmental entity being available for inspection, including things like the deliberative process privilege and myriad other things. Individual privacy interests, citizens having home address, phone numbers, social security numbers. There are categories of information that recognize other countervailing interests. Just because a record is in the hands of a public entity and may, in fact, reflect governmental conduct, doesn't mean it's open. It's not an absolute access statute. So, what are the, as I said, we're going to walk through quickly what constitutes a public record, how do you access public records, and then the exemptions from this broad legislative declaration. And I'll tell you, we spent time at lunch talking about how many of us are transplants or immigrants to Colorado from other states. And I have newsroom personnel who come from neighboring states, not even neighboring states, other states like Florida and Texas, and who have different regimes. And a colleague from one of the newspapers came from Florida and said, Colorado's Open Records Act has this broad definition that everything is a public record unless it's exempt, and then it goes on for 5 pages. He likened it to being Swiss cheese that's full of holes and has very little cheese. That's a ball of cheese. But that's the perspective of former Floridian. So a public record is, and I won't walk you through all of the details, but it's essentially any record, any writing that is, which includes data, documentary material, photographs, certainly electronic mail, any record maintained in any format that is made, maintained, or kept by a governmental entity. And that includes city government, county government, state government, special districts, one agency or institution of a political subdivision of the state has been very broadly construed to quasi-private entities like the Stapleton Development Corporation, a private corporation that was put into place to redevelop the former Stapleton Airport property, has been deemed to be a public, an institution or agency of a political subdivision. So it's basically any record that is in the possession, custody, or control of any governmental entity for use in the exercise of governmental functions. The statute says for use in the exercise of functions required or authorized by law or administrative rule. Rolls off the tongue, doesn't it? Anyway, it's for use in governmental functions. So the fact that a record is in the possession of a governmental entity, it may have even been made by a governmental actor, doesn't mean it's a public record. It has to bear some reasonable relationship to the exercise of governmental functions. So the two cases that prove this point, one is, you all remember the sexting case between Tracy Baker, the former clerk and recorder of Arapahoe County, who had a romantic relationship through text messaging with his subordinate. And even though they signed forms that said everything they exchanged on that county-provided texting system was a public record, was subject to disclosure, the Colorado Supreme Court said it isn't. When they're just engaging in romantic discussions during the workday on the public's dime, those records don't bear a reasonable exercise, a reasonable relationship in the exercise of functions, and those purely sexually explicit messages are not public records, despite the fact that they were made by government officials, they were maintained by government officials. They're just the content didn't bear any relationship to governmental functions, says the Colorado Supreme Court, and that is the law.
There's a joke in there.
And more recently, in the case I had the misfortune of taking up the Colorado Supreme Court, the former governor, Bill Witter's phone records that disclosed with whom he spoke during the workday, Monday through Friday, 8 to 6, in his capacity as governor, conducting official business of the governor. The phone records associated with his private cell phone, because he paid for that cell phone himself, were not public records. Because the governor, the evidence was the governor never referred to those cell phone records, and so they weren't either made, maintained, or kept by Governor Witter for use in the exercise of governmental functions. But those are the exceptions. The rule is that any record that is in the possession, custody, or control of a governmental entity that does bear some reasonable relationship to the exercise of governmental functions is a public record. And I would note that that includes databases. So writings is the sub portion of what is a public record, and it includes stored data without limitation, electronic mail messages, unquestionably email, regardless of what server it's on. A Gmail account, as the mayor of this town once famously, the former mayor, once famously told the U.S. Olympic Committee head to send all emails concerning the relocation of the headquarters to his personal email account, because the Gazette had asked to inspect all of the records and he didn't want those records being seen by the Gazette. It doesn't matter if they're on a Gmail account or any other private system, so long as they were made by a governmental official for use in the exercise of official functions, as those emails clearly were, they are public records. Now, it doesn't include computer software, but that's different from the actual text messages themselves. So that's the definition. Now, there are certain exclusions from the definition. And as I said, criminal justice records, records made, maintained, or kept by any sheriff, police department, or criminal agency are excluded from this middle column on that chart. Work product prepared for elected officials. And that's an important qualifier. It has to be for elected officials. And work product is defined. I don't have time to go through all of these exemptions. We can talk about how these are played out both in statute and in case law. But work product has to be something that is deliberative in nature, something that is intended to help an elected official make a policy decision. And there are a number of other exemptions from the definition of public records. But other than these specific exemptions, again, we begin with this overarching definition that any record that reflects governmental conduct or bears a reasonable relationship to that is a public record. Work product, as I mentioned, applies to interagency, advisory, deliberative materials conveyed to an elected official, to assist the official, and it's not waived. This is one exemption, like others, that the statute very clearly says, even though material may be work product prepared for an elected official, that elected official has discretion to release them to you anyway. So when we get into how to ask for public records, the general advice we always give to journalists and citizens alike is ask. There's never any harm in asking, even if something might in fact be excluded from the definition of public record, even if it's not something that is expressly statutorily waivable. There's no harm in asking. If somebody provides you a record, even if it's not a public record, you have it. So when we field calls for press association members, and people say, are we allowed to get this record? And I say, yeah, it's the jailhouse law. It's by statute, it's declared to be a public record. Why aren't they giving it to you? Oh, I haven't asked you, and I just want to know, are we allowed to get it? And I say, you know what, ask first, and then call me if they tell you you can't have it. Because if you get a record, then there's no issue. So there's never any harm in asking for anything, including work record. So now I'm going to talk about some of the exemptions from disclosure. Again, we begin with a broad overarching declaration, all public records that reflect the official conduct of governmental entities at any level, made, maintained, or kept by any governmental entity, are presumed to be open unless one of the exemptions, those pages of Swiss cheese holes, apply. So the Swiss cheese holes fall into two categories. Permissive exemptions, where the custodian of records may refuse to disclose a record upon finding that, upon that custodian's opinion, that disclosure would be contrary to public interest. That's the qualifier for what are called permissive exemptions, that the custodian has discretion whether or not to release these records. And that's the overall, the first of these is police investigations, intelligence, information and security procedures. And this is essentially the entire Criminal Justice Records Act, with the exception of some records that are records of official action. Any record of a police department or sheriff, they generally have discretion to withhold them if, in their opinion, it would be contrary to public interest. So why would this be in the Public Records Act? Because sometimes those records are in the hands of a non-criminal justice records agency. For instance, Child Protective Services or Department of Human Services might have police reports or other investigations. So they're not criminal justice records necessarily in the hands of a court custodian, but the same standard applies. And then there's certain specific detail things here that we're not going to go through individually, but there are a series of permissive exemptions for test questions and real estate appraisals prior to an actual transaction being completed. I might even have a second slide. No. So then the second category of exemptions are the mandatory. A custodian of records shall not. First provision, 2A, I think, says may not disclose. This 3A, or 3, under 2472-204, says shall not. So these are clearly materials that cannot be provided by the custodian. And they include things like medical, mental health, sociological, scholastic achievement information, personnel files, which I'm going to spend a second talking about, letters of reference, trade secrets, privileged information, confidential commercial information. And I'll tell you that we don't have time to go into all of these categories, but through case law, these have been narrowly limited. Not all commercial information is subject to a mandatory non-disclosure. It has to be almost like a trade secret, but has to produce competitive harm to a private entity. And it's confidential commercial information of a private entity, not the government's confidential commercial information, and that's set of law. And then there's certain particular categories. Every year, the legislature's in session now. There are proposed amendments to the CORA this year, as there is in every legislative term. And that list of holes in the Swiss cheese grows with each term, and there are exceptions to the exceptions, and it makes for a confusing statute, even for lawyers to understand. Mandatory non-exemptions continue. Records of sexual harassment, complaints, or investigations within a governmental entity. application materials for any non-finalists for an executive position. Vanity and disability license plate, all right? Deliberative process privilege is a very large exception that is listed here under 3A, but in fact, as this slide points out, it's actually not truly mandatory. It is a waivable discretionary disclosure. And in fact, it has to be balanced against public interest. So, last but not least, the record you asked for is in none of the above. It's not in a permissive non-disclosure exemption or a mandatory non-disclosure exemption. A records custodian still has a provision at the end of this statute that deals with disclosure that says, nonetheless, even though no exemption applies, in the particular circumstances, unique circumstances of this particular situation, disclosure would cause substantial injury in public interest, which is a higher standard than the Criminal Justice Records Act, contrary to public interest. But anyway, it requires extraordinary circumstances. And our public courts found that this test had been met in one occasion, the Columbine case, where the autopsy reports of the victims shot dead at Columbine were deemed to be subject to non-disclosure because of the extraordinary, what then we felt was a unique, only circumstance ever in Colorado, circumstance that the legislature could not have foreseen. And that's what this provision requires.